5 seconds to go. Start. When the same was presented for an encashment, it was dishonored as the appellant had closed the account. Stop. Criminal case number 26 of 2000 was pursued under section 138 of the NI Act, which was dismissed, against which an appeal was pending before the High Court. Stop. Para. Original suit number 112 of 2003 and original suit number 266 of 2004 came to be dismissed wide. Judgment dated 6th January 2004 and 29th July 2005 respectively. Stop. As against both the judgments, appeals were preferred before the High Court. Stop. Para. The appeals against the judgments in criminal matters were allowed by the High Court, wide common judgment and order of conviction and sentence dated 28th October 2008 and 30th October 2008. Stop. Para. In appeal, original suit number 266 of 2004 and original suit number 112 of 2003 were decreed by the High Court, wide judgments dated 8th August 2011 and 3rd February 2012 respectively. Stop. Para. The appeals against all the three judgments of the High Court are before us and are being disposed of wide this common judgment. Stop. Para. We have heard Miss Neha Sharma, learned counsel appearing for the appellants in all the appeals, and Mr. V. Prabhakar, learned counsel appearing for both the respondents in all the appeals. Stop. Para. Miss Neha Sharma submits that the High Court has erroneously reversed the well-reasoned judgments of the learned trial court. Stop. She submitted that blank checks issued in the year 1992 by way of security for chit funds were misused by the respondents in the year 1999. Stop. She further submitted that in the year 1999, when the checks were sent for encashment, the appellant was no longer the proprietor of Messrs. Brinda Engineering, and the bank account on which the said checks were drawn was not operated after 1992, and had already closed in 1997 due to non-operation. Stop. She further submitted that even before the account was closed down, the wife of the appellant became the sole proprietor of the enterprise, and thus, the appellant could not have signed the said checks in the capacity of the proprietor of Messrs. Brinda Engineering. Stop. Para. The learned counsel submitted that the respondents herein did not have the financial capacity to lend an amount of rupees 3 lakh each as on 20th October 1998 and 25th October 1998, when the promissory notes were said to have been executed. Stop. It is further submitted that although it was the respondents' case that they had given the amounts out of their agricultural income, since they had not declared the same in their income tax returns from 1992 to 1999, thus, there was no material to show that they could have lent money. Stop. To buttress her submissions, the learned counsel relies on the judgment of this court in the case. Stop. Para. Per contra, Mr. V. Prabhakar, learned counsel for the respondents, submits that the appellant Rajaram had failed to produce any material evidence to substantiate the claim that his wife subscribed to the chit funds run by respondent. Stop. He submitted that the High Court rightly observed that no material was produced by the appellant Rajaram to prove that the checks and promissory notes were issued only as a security for such a chit. Stop. He further submitted that no legal proceedings were initiated for the recovery of the alleged amount due by the appellant either. Stop. Para. The learned counsel submitted that there arose no occasion for the appellant Rajaram to issue a blank check in the year 1992 for a chit to be subscribed much later in the year 1995. Stop.